Good afternoon, everybody, and welcome to our Fashion Law webinar today. Our webinar today is on the subject of IP and Brexit. How are fashion brands affected? My name is Stephen Sitkin. I am a partner at Fox Williams and I chair our Fashion Law group. And I'm joined today by my partner, Simon Bennett, who leads our IP team here at Fox Williams. During the course of our webinar this afternoon, Simon is going to be addressing the issues that need to be considered so far as the fashion industry is concerned when it comes to IP and the end of the Brexit transition period, which is just over 6 weeks' time if you've still to prepare. Simon's going to talk for about 15 minutes. This will then be followed by a Q&A session. There will be an opportunity for everyone to submit questions using the facility that you have via your screen. We will attempt to answer as many questions as possible in the time that we have for our webinar. Questions that remain unanswered will get an answer after the webinar has come to an end. In addition, if you want to look at this webinar again, there will be a facility for you to do so, as it will be recorded. And finally, before we get started, just to mention that at the end of the webinar, there will be a online survey form. We should be grateful if you could complete it and tick send. That will help us because it gives us an idea of the various issues that are addressed in the survey so that we can deliver better webinars going forwards. But without further ado, I would like to hand over to Simon and for Simon to take us through IP and Brexit, how fashion brands affected. Simon, over to you.
Thank you very much, Steve. Thanks very much to everybody who's joined us today, this evening or this morning or this afternoon, depending on the time zone you're in. So what I'd like to cover very briefly in the short time available is the main IP rights as they relate to fashion and how those will be affected by Brexit. So the first right is trademarks, very important, then copyright, then I'm going to look at designs, and then finally domain names. So let's start with trademarks. So trademarks, as everybody knows, exist to protect brands. And I've put up here on that just as a reminder some of the disputes that have been sort of fought over the past year or so. This was one Gucci against Guess, which in fact went all around the world. Gucci won in America and Australia in respect of the trademark protection it has for its designs on these shoes. But Gucci lost in the case in the EU and France and Italy, and Guess were not infringing Gucci's trademark. So that's just as a reminder of how trademarks can be used. In terms of the issue of Brexit, sort of got good news, I suppose, in most cases. If you have a current EU trademark, that EU trademark will, at the end of December this year, be converted into a UK trademark, and that is whether there's a deal or not. So deal or no deal, any EU trademark that you currently hold will be converted into a UK trademark. So that's good news there. There's a slight fly in the ointment in respect of trademarks that you might have applied for and are pending and have not been registered. You have to convert those into UK trademarks, and you have to do so within 9 months. So if you've got a pending application, you just have to watch that. If the application is still pending for your EU trademark as of 1st of January 2021. I put on the slide quite a few other points that should be remembered or should be noted when it comes to Brexit and trademarks. I think probably the most important one, which is probably one that is of most importance to the fashion industry is the issue of parallel imports, or sometimes called exhaustion of rights. Now, as some of you will know, the concept of parallel imports in EU terms means that you can put a product in the market, say in France. So you can sell, say, a pair of Levi's jeans in France, and then you can resell those same jeans under the trademark Levi's in the UK without any sanction from Levi's. So Levi's has exhausted its rights in the trademark for Levi's by putting it on the market in France, and that is known as exhaustion of rights. And that's been a concept that's existed for quite some time now in European trademark law. It's going to get slightly complicated after Brexit because there's no agreement yet on how the EU exhaustion of rights will be dealt with. The UK government has said that they will still recognise EU exhaustion of rights, which means that the example I just gave you of a pair of Levi's jeans being sold in France can then be resold in the UK without any problem. But there's no reciprocal agreement yet by the EU, which means that if you sell a pair of Levi's jeans in the UK, you can't then resell those in France. Levi's would have the ability, because of its trademark, to stop you from doing that. So that's quite a key issue that should be remembered, and you should note. It may change, of course, if we manage to get a deal and that issue is covered. But as things currently stand, that is one of the sort of major issues that you should watch out for with trademarks. Other than that, it's relatively straightforward what's happening. So that's trademarks. I can answer questions on trademarks afterwards if you have any. Let's look at copyright. So copyright, interesting couple of cases here that I've just put up just to remind people of what can be protected by copyright. What is interesting on the example on the left, the case of Charlotte Tilbury against Aldi stores, is that the court actually held, and this is quite a recent decision, that the makeup sets were protectable as copyright works. So the way in which the makeup is set out in those makeup sets was protectable, and Charlotte Tilbury was able to stop Aldi from selling a similar makeup set. So that was an interesting case that you might be interested in seeing. That, and then I've got the other case there, Designers Guild against Russell Williams. That's actually a House of Lords, as it then was, case, where the pattern, as you can see from the slide, was protected as a copyright work, and Russell Williams, whose pattern is on the right, was found to have infringed the Designers Guild print. So that's the sort of thing you get in sort of fashion law copyright cases. In terms of Brexit, again, some good news here. There are no major changes at the moment envisaged in respect of UK copyright law. And that's primarily because the UK, prior even to the EU, was a signatory to a number of international treaties that recognise the protection of copyright around the world in most countries. And because of that, that means that copyright protection is reciprocal in pretty much every EU country. So if you have copyright in a dress design, for example, or even a makeup set in the UK, you will have copyright in that same design or same set in France or any other European country. And that means you can enforce those rights and stop people copying. What will happen as time goes on, because once we're out of the EU, we will find probably that the laws will start drifting apart, because as the EU implements harmonising laws across the EU, which is what it has been doing for the past 20 years or so in respect of copyright, that will no longer apply to the UK. So any laws that are designed to harmonise laws across the EU will not be implemented automatically by the UK, unless, of course, the UK government likes the look of them and wants to implement them. So I think what's likely to happen over time is there probably will be more differences, but currently, or as things stand, from the 1st of January, there isn't going to be much change, which is good news. We like certainty. Designs. Now, just a reminder on designs. This, in fact, is an example of a case we did a few years ago, which we won, where we managed to protect, believe it or not, the fact that there's a hood attached to a gilet, and in what you can't see from the screen, in fact, are the button fastenings that are attaching the hood. And it was a combination of those features and the other aspects of the hood that we managed to persuade a UK court that there was UK unregistered design right and EU unregistered design right to prevent the other brand on the screen from selling a very similar item. Now, I've just mentioned there two design rights, two unregistered design rights, which currently exist and which will which will change a little bit once we do leave the EU. The UK design right, UK unregistered design right, will stay the same because that's a UK design law, so that is unaffected by Brexit. However, the EU unregistered design right will change. Now, the major difference between EU unregistered design right and UK unregistered design right is that EU unregistered design right protects surface decoration. Now, so what the UK government has done to prevent that right being lost as a result of leaving the EU is they are implementing a new law which allows fashion companies or any designers to protect surface decoration on their designs in addition to the physical aspects of their designs. So that's a good news story for designs. And on the slide, you'll see some more details on how that will operate. Registered designs, they will pretty much stay the same. EU registered designs will not apply to the UK, but then the UK has its own UK registered design anyway. So in fact, that means there won't be much change there. So again, I've put on the slides some detail on how that works. In the transition, once we do leave, if you have a registered EU design, you are lucky, a bit like trademarks, you will get a UK registered design automatically. So that's another good thing. There will be recognition for current EU designs. So people who've got EU designs will not be left out in the cold, and they will receive UK registered designs to protect their designs. So that is a good news story. However, in future, if you want to protect your design throughout Europe and the UK, you will need to file both UK and an EU design to do so. Looking at domain names, the important thing about domain names is really, in respect of Brexit, really only applies to .eu domain names. All other domain names are pretty much unaffected. So the .eu top-level domain name registry has said that to have a .eu domain name, you now have to have your place of business in the EU. Well, in fact, that's always been the case. But once we're out of Europe after 1st of January, anyone who's got a .eu domain name and they've registered it in the name of a UK entity, they will no longer have that EU domain name. It will be cancelled. So that's an important thing to remember. If you do have a .eu domain name, you need to designate an EU entity to hold that domain name. Otherwise, you will lose it. So that's an important thing to know. So finally, before we go on to questions, just to sort of round up on where we are and what IP and Brexit really means. First point is to review your trademark portfolios, I'd say, because you want to make sure that if you've got any pending trademark applications, you make sure that those go through as quickly as possible so that you can then convert them into UK trademarks if necessary. All your EU marks that are currently registered, they will be automatically converted into UK marks, so that's good. If you do have EU trademarks, you need to also appoint an EU representative as well. So no UK lawyers, UK trademark attorneys can no longer represent EU trademark owners at the EU trademarks office. So that's another sort of administrative thing that you need to do. In respect of designs, you need to look at your registered designs if you've got any. Again, if you are planning to file some, I would file them now, so you then get an EU one and a UK for free. So that would be worth thinking about before the 1st of January. EU designs can be registered within a matter of 2 weeks sometimes, so there's still time to do that before the 1st of January. With respect to unregistered designs, one thing which I haven't mentioned yet is that there's a publication issue there, and that is if you publish your UK unregistered design in the UK, you will then not be able to have protection for it in the EU. So you need to consider ways of simultaneous publication of designs in order to have protection in both the UK and the EU in respect of unregistered designs. Finally, as I've said earlier, think about if you've got any .eu domains, make sure that you transfer those into the ownership of an EU company or an EU entity to make sure you don't lose them. If you do have an EU domain, .eu domain name, you should have already been informed of this by the .eu registry because they've been quite good at sending notices out. But if you haven't seen those notices, please, we would be quite happy to help you on that if you need it. I think that's it for now. Unless there's any questions, I'll hand you back to Steve. I'm more than happy to answer any questions on any of the issues raised today.
Thank you very much for that, Simon. And we do have some questions, but as I'm hosting, I'm going to take advantage of my position and actually ask you a question, if I may. And it relates, just to make sure that everyone has got it, to this requirement that the .eu domain names will, as of 1 January, need to be held by an EU company, an EU registered company. And that isn't the case so far as EU trademarks are concerned. That isn't the case so far as registered community designs are concerned. Those can continue to be owned by non-EU companies, non-EU persons.
Yes, that is correct. The issue of holding of the domain names, that's a specific point. It will still be possible going forward for a non-EU entity, person, company, whatever, to hold an EU trademark or an EU design.
Fine, thank you. And another point just before we move on to some of the questions we've been asked. You mentioned about the speed at which registration can be obtained for a community registered design. Would you like to say something about how it compares in terms of cost to sometimes applying for an EU trademark?
Yeah, I mean, I think in terms of applying for an EU registered design, it's actually cheaper than applying for an EU registered trademark. Obviously, they tend to protect different things, but an EU registered design can be registered for sort of under €1,000, let's say. But an EU registered trademark, even assuming there's no objections, typical costs are more likely to be £1,500 or more.
Fine. Thanks for that, Simon. One of the questions that we have been asked as we have been involved in this webinar is concerning EU trademarks. One of our questioners has asked whether there will be a need to reapply for them over and above reapplying in terms of renewing them when the time for which they're registered comes towards its expiry. So would you like to say something about that? Will there be any need whatsoever to reapply for EU trademarks?
Well, if you've already got an EU trademark, there's no need to reapply because you've already got one. If you've got an EU trademark that's will be expiring, and EU trademarks expire after 10 years, you will need to renew that in the normal course of events if you want to keep it. In terms of UK trademarks, if you get a new trademark, UK trademark, as a result of the fact that you own an EU trademark, the expiry date or the renewal date of that UK trademark will be the same date as the EU trademark. So
it's sorry to cut across you. So it's not a case so far as these new UK trademarks are concerned that their first period of life will be as if you had applied for a new UK trademark. Their life will go to what would have been the case had they remained just EU trademarks.
Correct. Yes.
Okay. Thank you for that. Good question. In fact, somewhat concerning question, as it may give some ideas to the Chancellor of the Exchequer. If I have an EU trademark that is registered, do I need to pay any taxes for the creation of the new UK trademark, or is it a freebie from the UK government?
Well, the good news there again, yes, it is a freebie. So, and this was already put in place well before COVID. So perhaps it would have been a different story had it been put in place afterwards. But no, there's no costs involved in once your UK trademark is created as a result of the EU trademark, you receive it automatically, and you don't have to pay anything. So that's good. That's another good news story there.
Slightly more detailed, and you may not be in a position to answer this. You've referenced the fact that for EU domains, there is a need for the EU domain name to be owned by an EU incorporated company or an EU national. One of our viewers has asked whether the same is the case in respect of a national domain name. So, for example, a domain ending .fr, .de, .nl. Is that an issue which falls under the national laws of the relevant member states?
The issue of these are what you're talking about here are country level domain names, yep. CCTLDs they're called in trade. Now it differs depending on the country as to whether you have to be of that country, as it were, to hold that domain name, and those are the rules are made up by the registry that has been given the mandate to run those CCTLDs for those countries. Some countries do specify that you have to be a part of that country, or you have to be in that country. So, for example, take a random example, Colombia, which is .co. You do not need to be resident in Colombia, a Colombia company, or in fact have any connection with Colombia to be able to register .co. The same goes with .tv. .tv is the country level domain for Tuvalu, the Pacific island of Tuvalu. Who knew? Again, you do not need to be in that country or on that island to have that domain name. So it does depend on the country in question, and it differs depending on which country you're talking about.
Fine, thank you for that. Thanks for the clarification. During the course of your presentation, you mentioned the issue concerning EU trademarks and registered community designs, which haven't as yet been granted. In other words, are still pending as we reach 31 December, the end of the Brexit transition period. There is inevitably going to be the possibility that some of these pending EU trademark applications and registered community design applications will take some time to move through the process before they obtain registration. And we could be in a position that come 30 September next year, they remain unregistered. For those looking further ahead, and possibly being in a position where come towards the end of this 9-month period, their application to register either an EU trademark or a registered community design is still pending. How quickly can we move to obtain or to apply for registration at the UK Intellectual Property Office in order to at least provide some degree of protection so far as clients are concerned? Or perhaps it might be a case that applicants should put in fresh applications before we leave, in order for those fresh applications at least to have the benefit of UK registration.
Yeah, I mean, in fact, that was what my answer was going to be to your question, that the the advice is that you file a fresh application if you can, to protect your position, and you do that straight away. So if you've got an EU pending application now that's unlikely to grant before the 1st of January, recommendation is to file a UK application now to protect your position, so that you've got that in the bag, possibly or hopefully, so that whatever happens to your EU mark, because your EU mark might be refused for whatever reason. So it's better to have that UK one pending as well. So you're hedging your bets.
And just following on from the issue of hedging bets, a question that's just been received is the following. Is it possible that simultaneous publication of a design within the UK and the EU might be problematic in terms that it will not be recognized by either the EU or the UK, and the designer would have to choose between a UK or a community unregistered design right?
Yes, the answer to that question is yes, it is possible that might happen, because at the moment we don't have any clear answer on whether simultaneous publication will in fact work. We have been operating on the assumption already, in fact, and there is case law that backs this up, that for designs which are published outside the EU, but simultaneously within the EU and other countries such as the US, we have been working, or at least some people have been working on the assumption that is enough to create an EU unregistered design right as it stands. So what the hope is, that the courts will carry on in that tradition, but it can't be guaranteed. And given that EU designs can be recognised in all EU countries, and each EU country has the right to rule on what is an EU unregistered design and what isn't, there is the risk that there could be certainly uncertainties and possible differences until there's a final ruling from the CJEU on what is meant by publication. So it is a difficult one at the moment, that particularly given that we don't have any agreement on from the EU or the UK on whether simultaneous publication will be sufficient.
And on that, the case law that you just mentioned, Simon, is that case law of the Court of Justice of the European Union?
No, that's UK case law.
Oh, okay.
English case law, I should say.
There is a reasonable chance then that the UK courts will follow that.
Well, I would hope so. But then the trouble with that is that will only give you protection in the UK, and it won't give you that protection in the EU that you might need.
Okay. Last question, very briefly, again, one that's just popped up, is whether come 1 January next year, there will be any change in the protection of copyright in fashion designs in the UK?
Well, I think the answer to that is no, not initially. and it remains to be seen whether there will be changes down the line. But as things stand, copyright, if you have copyright on the 31st of December in the EU and the UK, you will still have copyright in that same item or that same in the EU and the UK on the 1st of January. So that's good because there's certainty there. Things may change as time moves on and case law changes things. But apart from that, that's the current position.
Fine. Simon, thank you very much indeed. I'm conscious of where we have got to so far as the time is concerned. So I'd like to bring this webinar to a close. Thank you all for watching this webinar. Thank you for your questions. A special thank you to Simon for his answers, despite my best attempts to ask difficult questions. As I mentioned at the outset, if there are further questions, we will be happy to answer them, and we'll do so by responding via email. Further information about the work of our Fashion Law Group can be found at fashionlaw.co.uk. Further information about the issue of Brexit and how it affects businesses can be found on the foxwilliams.com website /Brexit-lawyers. Finally, there is an evaluation form coming up in a moment. Please do complete the form and return it to us. We do appreciate your answers. But until our next webinar, which will be on 1 December, and we'll be looking at the trend in fashion retail of late to move to turnover-based leases. Until then, it's a good evening from Simon and me, and thank you all very much indeed for attending. Thank you, and bye-bye.
Thank you.